Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. The code IBC 2016 casts upon an insolvency professional a lot of responsibilities, including balancing and protecting the interests of all these stakeholders, be it employees, suppliers, lenders, and also these statutory bodies in a systematic way, driven by the code IBC 2016. So friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the Act IBC 2016 and to navigate through the intricacies of its proceedings. So let us together embark on this journey to clarify the doubts as guided by the honorable courts of our country. So friends, let us today discuss an important case. So this is the case of Employees Provident Fund versus Jaykumar EPFO, which was decided on the 3rd of January 2025 by the Honorable NCLAT, Delhi. So friends, this judgment answers the following questions. Whether after imposition of moratorium under Section 14 of the IBC, assessment proceedings can be carried on by EPFO under Section 7A, 14B, and 7Q of the EPF and MP Act 1952. Whether any claim on the basis of assessment subsequent to imposition of the moratorium can be admitted in the CIRP, and whether claims which were filed by the appellants subsequent to the approval of the resolution plan by the COC could have been admitted in the CIRP. So let us look at the factual background of this case. Now, CIRP against Decent Laminate Private Limited, which is the corporate debtor, commenced via an order dated 3rd of May 2021, passed by the Honorable NCLT Ahmedabad bench. On 16th of June 2021, the RP forwarded the copy of NCLT order dated 3rd of May 2021 to the appellant. The appellant initiated proceedings under Section 7A of the Employees Provident Fund and Miscellaneous Provisions Act 1952. On 22nd of June 2022, summons was issued under Section 7A with a copy to the IRP. The IRP appeared and informed that he does not have relevant records. On 9th of May 23, summons were again issued to the establishment under Section 14B and 7Q of the EPF and MP Act to show cause as to why damages under Section 14B and interest under Section 7Q of the Act may not be levied and recovered. On 11th of May 23, the claim of 76 lakhs was submitted before the IRP. Now, the assessment order under Section 7A was passed on 11th of August 23. An order under Section 14B and 7Q was issued on 16th of August 23. On 5th of September 23, the RP replied that the claim cannot be considered as the plan has been approved by the COC. An IA was filed by the appellant, praying for direction to the IRP to admit the total claim of rupees 2 crores and 35 lakhs. Now, the adjudicating authority by the impugned order rejected the application. The AA noticed in the order that the order under Section 7A, 14B, and 7Q was passed only on 11th of August 23, and the resolution plan had been approved by the COC long back. Now, it was held that IBC is a time-bound process, and the claim which was submitted by the applicant at a belated stage after the approval of the resolution plan was rightly rejected by the RP, aggrieved by which order this appeal has been filed. Now, what are the questions before the Honorable Appellate Tribunal? Whether after the imposition of the moratorium under Section 14 of the IBC, assessment proceedings can be carried on by the EPFO under Section 7A, 14B, and 7Q of the EPF and MP Act 1952, whether any claim on the basis of assessment subsequent to imposition of moratorium can be admitted in the CIRP, and whether claims which were filed by the appellant subsequent to the approval of the resolution plan by the COC could have been admitted in the CIRP. Now, what is the interpretation of Section 14(1)(a) of IBC? Now, the plain reading of Section 14, subsection 1 indicates that expression, suits or proceedings against the corporate debtor has been used. The word proceeding is not qualified so as to confine it to proceedings before the civil court. The proceedings which have the effect on the assets of the CD are all covered in the expression proceeding. Section 446(1) of the Companies Act 1956 uses the expression suit or other legal proceedings. Now, there is marked difference in the expression used in Section 14, subsection 1 of the IBC. Section 446(1) of the Companies Act 1956 uses the expression other legal proceedings, while Section 14, subsection 1 uses the expression proceedings. Now, in view of the law laid down by the Honorable Supreme Court in Rajendra K. Bhutta versus Maharashtra Housing and Area Development, it is clear that no proceeding can continue after imposition of moratorium, which has the effect of depleting the assets of the corporate debtor or creating new liabilities on the corporate debtor, since the object or purpose of IBC is to resolve the corporate debtor. Also, it was held that after the imposition of moratorium, a statutory fees takes place. Also, it is a well-settled law that a ratio of judgment of the court has to be read in reference to the facts which have come for consideration before the court. And it is well settled that ratio of a judgment cannot be read as a statute. Now, whether after moratorium has been imposed, it is open for EPFO to proceed with the assessment proceedings. The judgment of the Honorable Supreme Court, that is Sundaresh Bhatt, liquidator of ABG Shipyard, does not support the submission of the appellant that after imposition of the moratorium under Section 14, subsection 1 of IBC, it was open for the EPFO authority to proceed with the assessment and conclude the assessment. In the present case, admittedly, assessment has been completed after initiation of the moratorium. The Honorable Appellate Tribunal is of the view that once order of liquidation is passed, moratorium under Section 14 comes to an end, and moratorium under Section 33, subsection 5, which is differently worded, comes to play. Under Section 33, subsection 5 of the IBC, the expression used are suit or other legal proceedings, which occurs in Section 446(1) of the Companies Act 1956. Thus, bar is only against suit or legal proceeding, and there is no bar against the assessment proceedings to be conducted by statutory authorities, including the EPFO. Thus, after the liquidation, it is open for the EPFO to carry on the assessment. Section 33, subsection 5 of IBC cannot be held to apply on assessment proceedings. However, while looking to the expression used in Section 14(1) of IBC, assessment proceedings before the EPFO cannot be continued after initiation of the CIRP. So, friends, we conclude that after initiation of moratorium under Section 14, subsection 1 of IBC, no assessment proceedings can be continued by the EPFO. If after an order of liquidation is passed, Section 33, subsection 5 of IBC does not prohibit initiation or continuation of assessment proceedings. No claim on the basis of assessment carried during the moratorium period, which is prohibited under Section 14, subsection 1 of IBC can be pressed in the CIRP. So friends, we see how the honorable courts are working diligently to provide clarity to all the concepts and all the issues to bring IBC in a systematic way and to ensure that the interests of all the stakeholders are protected. So friends, I trust that you find this both interesting as well as enriching. So for further insights into such judicial pronouncements under the Act IBC 2016, please like this video and subscribe to my YouTube channel. So friends, thank you for being with me today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.